Hello, I'm DRoger, General Counsel for the Las Vegas Police Protective Association. In this segment, I'm going to talk to you about the Community Caretaking Doctrine and warrantless entries, and the Nevada Supreme Court case of Hannon v. State, which is a 2009 decision. The facts of this case will sound very, very familiar to you. In Hannon, a neighbor called 911 and said that the neighbor heard yelling, screaming, and thumping against the walls in the neighbor's apartment. Officers responded 45 minutes later. When they knocked on the door, a female answered the door. She was red-faced, crying, and breathing hard. In the background, officers observed a male who appeared to be flushed and very angry. When the officers asked if anybody was hurt, the female said no. When the officers asked if anybody needed assistance, the female said no. Officers persisted and said that they just needed to go into the apartment and check to make sure everything was okay. And when the female refused to consent, the officers pushed their way into the residence and found some contraband. The Nevada Supreme Court held that the entry was illegal. Sound familiar? Those facts pop up almost in every DV call that you see. And the Nevada Supreme Court said that based upon Brigham City versus Stewart and the emergency doctrine, there was no emergency. The Nevada Supreme Court held that the officers did not have an objectively reasonable belief that anybody in the residence was seriously injured and in need of emergency assistance. In addition, the Nevada Supreme Court held that the officers did not have an objectively reasonable belief that anybody was in immediate need of protection. So, that is the emergency doctrine, that is the community caretaking doctrine. What is the takeaway from that? Obviously, the test is whether you have an objectively reasonable belief that a person is in immediate need of emergency assistance because of an injury, or they are in immediate need of protection. When you respond to these DV calls, be mindful of these cases because if you force your way into the residence and you cannot articulate an objectively reasonable basis to believe that someone is harmed and in need of emergency assistance or is being threatened immediately and they are in imminent need of assistance, you may be violating their civil rights and you may be sued. And so make sure that you are able to articulate your reasons for going into a residence without a warrant and without the person's consent. And if you can't, then you have to stop. Another type of situation that we see often is welfare checks, where an elderly person hasn't been responding to neighbors' calls. And under those circumstances, I think you can articulate a need to go in because elderly people are at risk, and you'll be able to establish the facts and circumstances before you enter the residence to justify your entry. But as always, be very, very careful and make sure that you articulate your reasons in your reports. And if you have questions, call me at PPA or email me at DRoger@LVPPA.com. I hope this series of videos has clarified Metro policy and clarified in your mind what types of circumstances amount to an emergency. Thank you.